Appurtenant, belonging to, appended to, annexed to, providing a benefit. Real property is said to be land, anything attached to the land, anything appurtenant to the land, or anything immovable by law. Appurtenant means belonging to, appended to, annexed to, or providing a benefit. Easements and stock rights in a mutual water company are two commonly discussed appurtenances to real property. The most unusual appurtenance is the stock rights in a mutual water company, and a question on my broker's exam dealt with this issue. Because the owners of land can band together for the purpose of using water from the land, the stock rights in a mutual water company go with the land. They are appurtenant to it. Likewise, easements belong to the land and therefore are appurtenant to it. If a neighbor has an easement for a driveway across a property and the property is sold, the easement goes with the sale. The new owner will have to accept the easement as the easement is appurtenant to the land. Appurtenances are things that are belonging to, appended to, annexed to, or providing a benefit to the land, and therefore are included in the package that is real property. Lien, claim on real property for the purpose of collecting a debt. A lien is a claim on real property by someone other than the owner for the purpose of collecting a debt. A lien can be voluntary, as in the case of a mortgage or trust deed, or involuntary, as in the case of a mechanic's lien, tax lien, or court judgment. A lien is simply a piece of paper that is filed with the county clerk that acts to encumber a property so that in the case of a refinance or transfer, the lien will likely get paid. A lien is a claim on real property by someone other than the owner for the purpose of collecting a debt. Related words: money encumbrance. Writ of attachment, court-held property pending the outcome of a lawsuit. Lis pendens is a notice recorded at the county clerk's office of pending legal action, which works to encumber the title of a property so that it cannot be transferred until the outcome of the court action is clear. A writ of attachment is very similar in that the court files the writ of attachment with the county clerk as an attachment lien to a property. The writ of attachment is a specific and involuntary attachment lien. The effect of lis pendens, or a writ of attachment, is the same. They restrict the transfer of a property so that the property can be used to pay a judgment if and when that court action outcome is decided. Related words: action, lis pendens. Broker, licensed real estate transaction facilitator. A broker is an agent in the agency relationship, and the seller or buyer is the principal in the agency relationship. Business-wise, a brokerage is run by an employing broker who manages his associate licensees. There are two types of licenses in California, and an employing broker will have a broker's license, and the associate licensees can have either a broker's license or a salesperson license. When a seller signs a listing agreement with an associate licensee, he or she is really signing an agreement with the employing broker. And although common language has buyers and sellers talking about their, quote, real estate agent, end quote, in most cases they are talking about an associate licensee, and the employing broker is their, quote unquote, agent in the agency relationship. In California, only a person with a broker's license may make real estate transactions. However, an associate licensee can act on behalf of a broker. A broker is a person with a broker's license. Synonyms: employing broker, related words: brokerage, associate licensee. Alienate. To transfer or sell a property with To transfer or sell a property. The word alienate in real estate means to sell, give, or in one way or another to transfer property from one person or entity to another. Alienate is the verb form and alienation is the noun form. Alienation clauses or due-on-sale clauses are often found in property loan documents. An alienation clause would work to establish that if a property is transferred from the current owner in any way, the loan will be quote-unquote called or due in full immediately. Why? Because the bank's agreement for repayment is with the current owner, not some unnamed consequent owner. In generations past, it used to be more common for loans to transfer with the property, but it's not common today. To alienate is to sell or transfer real property. Synonyms: convey, transfer. Related words: alienation. Quiet enjoyment, QE. Owner's right to enjoy property without interference. Property ownership is said to be a bundle of 5 rights. The bundle of rights for real property is said to include the 1. Right to possess and exclude. 2. The right to use within the law. 3. The right to encumber or borrow on the value of the property. 4. The right of quiet enjoyment. And 5. The right of transfer or convey. The right to quiet enjoyment is pretty much exactly what it says. When something intrudes upon the right, the law affords opportunities to remove the intrusion. Quiet enjoyment is one of the 5 rights of the bundle of rights of property ownership and is the owner's right to enjoy property without interference. Related words: bundle of rights. A paper. Loan conforming to Fannie Mae requirements. A paper is a loan which conforms to Fannie Mae and Freddie Mac requirements. Another name for a paper is a prime loan. Another name for a loan which conforms to Fannie Mae or Freddie Mac requirements is a conforming loan. In 2012, the conforming loan limit was $417,000, and the jumbo loan limit for conforming was $625,000. Subprime loans are B paper or C paper. Why would we want a loan to conform to Fannie Mae or Freddie Mac requirements? Because these programs guarantee that such loans will be backed up by the government in case of default, and conforming loans are easily sold on the secondary mortgage market. A paper is a conforming and therefore government-guaranteed loan. Synonyms: prime loan. Related words: conforming, secondary mortgage market. Express contract versus implied contract. Written or spoken contract versus suggested by actions. Express means made clear by writing or speaking. Implied means made clear by actions, conduct, or behavior. An express contract is one which is written or spoken, and this is the most common form of contract people think of. The implied contract is around us all the time, however. My favorite example is going into a sit-down restaurant, being seated at a table, ordering, and eating. These actions imply that the bill is going to be paid. Eating at a sit-down restaurant is an example of an implied contract. An express contract is one that is spelled out in writing or in speech. Related words: express versus implied. Grantor. Person transferring or conveying the property. When transferring a property from one person or entity to another, there is a grantor and a grantee involved. Transferring a property can be called conveying or alienating. The grantor is the person transferring the property. The grantee is the person receiving the property. Antonyms: grantee. Related words: transfer, convey, alienation. Interest. Rent paid to use money. Interest is rent paid for the use of someone else's money. There are different types of interest: simple interest, compound interest, amortized interest, and there are different ways to describe the quantity of interest: interest rate and annual percentage rate. Simple interest is the rate times the balance. 5% of $1,000 is $50. All banks use amortized interest because they get the interest up front. See amortization formulas elsewhere. An APR, or annual percentage rate, is the interest rate of a loan considering all fees. If the interest rate and the APR match, then there are no fees to the loan. Interest is rent paid to use money.